And we are live on Who Wrote That Up for You. Today is Thursday, October 20th, 2022. I'm Sonja Ebron, co founder at Courtroom 5.
And I am Deborah Slone, the other co founder at Courtroom 5.
We have a very interesting show for you today. Deborah, we've been doing this about 6 weeks now, this weekday podcast. I'm very proud of us and very happy about the audience that we're growing for both the live broadcast here and the podcast. Thought it would be a good time to just re-engage on the title of the show and where that title comes from. Who wrote that up for you? So we're going to talk about that a bit in just a moment. Before we get there, though, Deborah, what's on your mind? What is your issue of the day?
Well, today's issue is in both the don't do this at home department and the see what can happen when you handle stuff in the streets rather than in the courts department. Apparently, the sheriff's department in Hadley, Massachusetts was attempting to serve an eviction notice last week when a woman pulls up in an SUV with a flatbed trailer full of beehives. To stop the eviction, she jumped out of the SUV, flipped the hive tower off the flatbed, and released the bees on the members of the sheriff's department.
Oh,
She did not live. She did not. She didn't even live in the house, but was there to protest and attempt to stop the eviction. Several of members of the sheriff's office were hurt, were stung, and she's been charged. Allegedly, she said, "Oh, you're allergic? Well, good. Here's some bees."
oh my. That's badass, first of all. I understand I understand the motivation there. We have a really serious eviction crisis in the country, and obviously the government isn't addressing it, at least to my satisfaction or expectation. And so I understand that people often want to take things into their hands. It's not something I would do to address the problem. But you remind me, and it's a good time to just remind everybody. Government exists to keep people from doing things like this, right? To keep people from handling issues in the streets. And one could argue that if the government were addressing the eviction crisis in any meaningful sense, that you wouldn't have people out there releasing bees on the sheriff's department during an eviction. So this is a symptom of government failure. We've seen it so many times. Honestly, I mean, I just I don't know. I don't want to go on about it, but it seems to me that when the government fails its people so predictably, you can expect more and more of this type of behavior. And so I would rather
Exactly.
have capable government than people taking these matters into their own hands. For sure, there's nothing but chaos down that road. But we have chaos anyway. One could argue that the sheriff's department nationwide evicting people on the scale they're doing currently is a form of chaos in itself. So,
Mm,
yeah,
okay.
appreciate you bringing that issue to the fore. I tell you, who wrote that up for you is sponsored by Courtroom Five. At Courtroom Five, we believe the courts belong to the people, in particular to the people who use them, and we, the people, are coming to claim our courts. So that we don't have to be out here releasing bees on sheriff departments. Let's use the courts on some of these issues. But if you find yourself in court without a lawyer, or if you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and we hope to provide some relief for you there. All right. Deborah, again, we've been doing this little podcast thing, this live broadcast thing for 6 weeks. And on day one, we introduced the title of the show and just gave the background, the origin story, if you will, that drove the title here. Essentially, you and I were engaged in a foreclosure case. Chase had decided that they didn't want us living in the home we purchased anymore and filed a foreclosure suit, and we fought it. We had, I will say, made a strategic decision to end that relationship or at least alter it because we couldn't get the mortgage modification that we thought we deserved. This was, at the height of the financial crisis, and we were just never going to get any money out of that home, as it turned out. So, long story short, we made a decision to delay the progress of that case, to just stick our feet in the mud and slow everything down. It's something that lawyers do all the time, choose a strategy and execute on it. And we did that very successfully. As I recall, it took the bank more than 3 years to get an answer to their foreclosure complaint. And the case was settled quite favorably several years later. So, long story short, though, we were in the process of just slowing things down and had at one point decided that we wanted to subpoena and depose not only the bank's lawyer, but two vice presidents of the bank who we knew to be robo-signers. And you remember that big scandal from a few years back. And they were calling themselves vice president of this and vice president of that. And we knew for sure they didn't get an invitation to the Christmas party at Chase. And so we wanted to talk to them. We had found some mistakes in the paperwork and wanted to talk to them. And so at any rate, we made, I thought, a very powerful argument one day to be able to get those depositions done. You can't just send a subpoena to the bank's lawyer or to offices of the court, particularly when they're out of state. So we had to go through some procedural hurdles to get that done. But during the course of that oral argument, the judge, as you'll see, had a very interesting question for me that ended up being the title of the show. Let me just play a couple minutes of that hearing for those of you who haven't heard it. This is me making an argument rather, to the judge about why we ought to have the opportunity to depose all these people to get some answers before we had to answer the complaint. You'll hear a couple of bleeps. We have removed some names from the audio of that hearing just to protect their privacy, but hopefully that won't be too disruptive. Give us a couple minutes here. Now, there are, as I mentioned, a couple of other witnesses that we need to depose. Is the Chase vice president who verified the attachment of the assignment in October of 2012. We believe the court needs to know whether she will testify to that fact at trial or rather admit to perjury in her verification. Court needs to know that to determine whether is in fact a necessary witness. We've already handled that matter is, again, the Chase employee who executed the December assignment on behalf of MERS. That assignment, mind you, stated that MERS, and I quote from the assignment, does hereby assign, transfer, and set over unto Chase the subject mortgage. That's in direct contradiction to verification just 6 weeks earlier that the mortgage had already been assigned, transferred, and set over to Chase. And so we believe the court needs to know how he was able to make that assignment or whether, in fact, he was unable to make the assignment. The court needs to know that to determine whether, again, Ms. is a necessary witness in this case. I would just point out finally here that by drafting and filing the initial complaint with the Chase vice president's verification, essentially attested to the existence of an earlier assignment. Now, we all understand that an attorney representing a client doesn't make factual statements on any personal knowledge. She's simply representing the client. But again, a quick aside, if little Johnny throws a baseball bat through a neighbor's window and a lawyer representing that neighbor writes a complaint saying Johnny threw the ball through the window, that's the client's statement. But if the attorney attaches the ball with shards of glass to the complaint and attests to that in the complaint, well, that's some personal knowledge involved there, that the ball is attached to the complaint. And that's essentially what we have in this case. And we would suggest that herself attested to the attachment of an October 2012 assignment on the initial complaint. In contrast, by drafting, preparing, and recording the December assignment, she essentially attested to the non-existence of that very earlier assignment. And so I think the court... I'm sorry. My handwriting. I'm just. I think the court needs to hear her explanation of those contradictions. I can only laugh as I did then about that situation. You're on mute.
Exactly. If you'll notice, she asked who wrote that up for you, and I in the courtroom while I was in the courtroom watching her, I saw her be very engaged in the conversation. She was like, oh wow, what happened next?" And she was into the story, into being persuaded that ruling in our favor basically was the right thing to do. And so when she said, "Who wrote that up for you?" she was like, it was in a like almost a state of, "Oh, I'm sure you didn't, but just tell me who wrote this because I like it." So I felt that the document that Sonia and I wrote to say in court that particular document was something that she admired. And so, unfortunately, she didn't think we would write it, but it was something that she admired. And so I felt flattered. And Sonia, I mean, she was just really basically going up the hill with this wonderful argument, and she was almost at the crest. And here comes the judge says, "Wow, who wrote that up for you?" So it was magnificently stated, and the judge was impressed, and I, for one, am flattered. I think Sonia's flattered as well, but that just goes to the idea, the notion of a judge not really expecting certain people to come out with a certain argument, especially pro se litigants that are representing themselves in court. They don't always see arguments like this. Now, I have to admit, there are a lot of pro se litigants who are capable of representing themselves very well, but there are a whole bunch of those who aren't. And this judge apparently was more used to those who may have different types of argument. And so this was a good day because we won. We won this hearing, and so this was a really, really good day for us.
It was funny to see Chase's counsel trying to argue that that all of the subpoenas should be denied because they didn't disagree with anything we had to say. therefore there was no need for all that discovery. But it didn't work. It was a good try, but it
Yeah.
didn't work for him.
In other words, he didn't have an argument.
He did not. He wasn't
Yeah,
prepared for that one.
yeah,
I've become very sympathetic with judges these days. As you indicated, there are some pro se litigants who can capably represent themselves in court. We've talked to some of them on this show, and will continue to do that. But frankly, there are millions of people in the courts these days, and the numbers are increasing with the eviction crisis that we discussed, with the economy the way it is, more debt collection, more bankruptcies, all of these cases where people are having to represent themselves. Because obviously, if you've got trouble paying your mortgage, or you've got trouble paying a debt, or even are alleged to, you're not likely to hire a lawyer. And so
right.
people are being forced to represent themselves in our nation's courts in these very difficult and complex procedures. And so judges are overwhelmed with lay people trying to exercise the law, right, which belongs to all of us, and assuming that what they've seen on television, on Judge Judy's show and the other shows, is what they're facing, and that's and they're shocked to find that it's not that way. But judges are just overwhelmed, and so I certainly I understand this judge is wanting to just delve a little deeper here, because I don't look like a lawyer. I didn't look like a lawyer that day. I dress in regular, not even business casual when I go to court. I want to distinguish myself from the lawyers in the court, who are typically much better dressed when I go. But the judge did have a really difficult time hearing legal argument of that sort from someone who clearly wasn't a lawyer. And so I just thought, I was flattered, as you said, that she would be forced to ask that. What I'd like to see happen, though, what I'd like to see happen is for many more judges to be confronted with those sorts of legal arguments and be compelled to ask that same question from the pro se in front of them until it becomes the norm, and nobody is surprised when a pro se litigant can forcefully argue in a court of our law. So anyway, I won't ramble on there, but it
Exactly.
was a good day. As I said, we, by that time, Deborah had some, a fairly good understanding of how these things work. And one other thing I would just note is that I think one of the things we learned along the way is that in state courts in particular, judges generally don't even bother reading the pleadings, particularly when there are pro se's involved. Again, they've got a very heavy docket, and they're used to reading gibberish, and they know they're going to make their decisions based on the arguments when people come to court. And so we did write down some stuff, but I don't actually think this judge read our written argument at all. And so
Yeah.
that was a source of, and had she, I mean, maybe she would have had the same question, maybe not, but I don't think she took, I don't think she took the opportunity to read the argument beforehand because it wasn't much
Interesting.
different from what we delivered. But nonetheless, that is the origin of the show's, that's the backstory of the show's name. Who wrote that up for you? And again, our goal here is to get many more people who are representing themselves to be able to, capably argue their positions in court, so that a judge will ask them who wrote that
Who
up for
wrote that up for you?
you. Yep,
You know,
yep.
her next question would have been who helped you, who coached you.
Yeah, yeah,
Yeah,
exactly,
yeah,
exactly. Same thing. So
yeah, yeah.
that's okay. I would have told her, hey, I mean, we did this. I got my coach is sitting right next to me here.
Exactly.
Fantastic.
All
At any
right.
rate, Deborah, who won yesterday's quiz, if anyone, and what do you have teed up for us tomorrow?
Okay. We do have a winner today. The question was, which of the following is the least likely to be asserted as a defense in a contract case? Number one, mistake. Two, unclean hands. Three, accord and satisfaction. Four, contributory negligence. And the answer is four, contributory negligence. Of the four, contributory negligence uh, pri- typically would apply to, or typically is asserted in a negligence case like personal injury, medical malpractice, those kinds of cases, rather than a contract case. It's not impossible to assert a defense of contributory negligence in a contract case, but of the four, it's the least likely to be asserted as a defense. And the winner today is Tony T. All right. And
Congratulations
then
there.
today's quiz. What's the difference between a motion for summary judgment and a motion to dismiss? What's the difference between a motion for summary judgment and a motion to dismiss? If you want to participate in today's quiz, send your responses to quiz@courtroom5.com.
Fantastic, fantastic. That is great. Just wanted to shout out to one of our more loyal viewers, Eric. Thank you so much. I think he posted that while we were discussing who wrote that up for you, backstory. But appreciate you viewing so reliably, Eric, and appreciate your comment as well.
All right.
All right. Fantastic. Well, that is all we have for you today. As always, we'll maybe see you on tomorrow, on Friday. Look forward to the stream then. And hey, as always, everybody have a great day. Thanks so much.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.